Democratic state lawmakers say they want to be involved in Republican-led legislation aimed at reducing crime, especially after the deadly light rail stabbing.
Top Democrats really want to focus on mental health services in any proposed legislation, but they say first they need to have a seat at the table.
Yeah, our state capitol correspondent Dina Harley has more from Raleigh.
New legislation is coming from top Republicans in North Carolina after the fatal stabbing of Iryna Zarutska on a Charlotte light rail train last month. Some of them say her death was preventable.
Her life was tragically cut short because of the atrocious policies pushed by out-of-touch politicians and court officials that prioritize a perverted vision or version of equity.
Senator Phil Berger and Representative Destin Hall are drafting legislation to be tougher on crime. They want people with violent criminal histories to be held in jail more often. They want to end cashless bail, and they want more training for magistrates. The man accused in the light rail stabbing, DeCarlos Brown, was released by a magistrate judge on a recent nonviolent charge despite a history of violent felony convictions. Democratic House Leader Robert Reeves agrees that Brown should not have been out free, but he wants any new legislation to address mental health concerns for repeat offenders.
We've got to figure out what to do with people who fall in that gap. And the gap is people who are a danger to themselves, who are a danger to others that we know are a danger, and that we're not getting them off the streets.
Leader Reeves wants more support for law enforcement, including funding. He also wants to hear from magistrates and judges across the state about what they need to make well-informed decisions when releasing somebody accused of a crime. With both chambers led by Republicans, Reeves wants Democrats to have a seat at the table because he says there is no simple answer.
Innocent people walking on the streets every day shouldn't have to fear things like this in a civilized government. This doesn't go by party affiliation, race, gender, sexual orientation, religion, nothing. Everybody gets affected.
Again, that was Dina Harley reporting. We want to bring in our chief legal analyst, Khalif Rhodes. Khalif, obviously you spent time as a defense attorney. When you're going through these motions with the judge to decide whether or not a client should be released, what is the judge looking for? What does that process look like?
Well, I don't even have to go to my time as a criminal defense attorney. I can go to my time as the chief magistrate.
Yeah.
Tell me you haven't been a magistrate without telling me you haven't been a magistrate. That's what I say when I look at all this stuff. And I know we're talking about a terrible scenario that happened with a young lady that should not have lost her life. But in the aftermath, what has happened after that is a bunch of people in the room that have never been in the room. And that is the worst situation ever. If you're familiar with the term Occam's razor, it's something that says normally the simplest answer is the right answer. Right, great theory, works in a lot of places. Doesn't work in criminal justice reform. Doesn't work when you're talking about setting conditions for release. And that's what we're talking about. Yes, Hall, yes, Berger, they're looking at this situation like it's the simplest solution. Just lock them up and keep them in there. But let's walk our way through this scenario as someone that's done it. This individual, Brown, was arrested back in January for a crime that was at the maximum 120 days. So between January and February, March, April, you can add even May, he would have ultimately, by statute, by our Constitution, had to been released within 120 days because he would have, even if he waited in jail that entire time, he has to be let out for anything other than that. So my concern, my question is, you're saying lock him up, keep him in there. Well, even under that scenario, if you locked him up and kept him in there, he ultimately would have been released at some point way prior to when this incident occurred. So that response, that rush to judgment, that quick, we need to throw something at it approach wouldn't solve this scenario because he still would have been released even if he done the maximum amount, which no one is doing that for the misuse of 911 anyway. But I'm saying if it's the worst case scenario, he would have been released if he never even had a court date. He would have had to been let out. And so saying, making sure that magistrates keep violent criminals in, yes, he has a violent past, but our laws require that I look at this individual for the charge that they are committed now. Yes, their past helps me determine that. So you're asking the question, me as a magistrate, how do I make that determination? The question is simple. What is the likelihood of this person appearing in court, and what's the likelihood of them committing a crime, specifically a new violent crime? And there is a risk assessment. It's going to put them on a number from 0 to 6, letting me know, hey, what is this person's ability? So I'll look at their past. Have they been convicted of a number of crimes? That will go in a factor, but also the charge, the seriousness of the charge. Misuse of 911 will fall extremely low. His criminal history will be extremely high. So he probably would have been a 6, being very likely to commit a new crime, but being low because of this type of crime. And that's the scenario that you put a magistrate in when they're looking at this. And this is happening probably 400 or 500 times a night for an individual. They're not just doing this a one-off. This is not like courts you see on TV. This is them doing this in this scenario hundreds of times every night.
So, Khalif, if you don't think this is the path forward, what is the path forward? And is there a blanket path, or like you said, does it have to be individual case by case?
Well, when you do an assessment of a person's ability to commit crime and commit violent crime and appear, it does have to be based on the individual. That's what the statute says. Yeah. I actually helped redraft our bail policy here in Mecklenburg County, so I'm intimately familiar. And I ripped some of those things out of there, what used to be there, which is we had a catch system. It would be something on there that says, hey, you individual Julian, $25,000 for that specific crime. You, Annie, $50,000 for that specific crime. Make no assessment of you individually, of what your ability to appear and come. The statute requires that you do that. In terms of what I recommend, it's a mixed bag of both, specifically the mental health portion, because magistrates, they do have the ability, and I know we have a talk of folks saying they want to do that as well, making sure magistrates can do involuntary commitments. Well, we can already do that. I issued a number of them. The first portion of the involuntary commitment process in Mecklenburg County, I should say North Carolina, is the magistrate. They set a conditional, they set a consent order for that person to go. Then within 10 days, a judge has to have a hearing. But before that 10 days happens, a magistrate does that. So that's the part of why I say folks don't know what's happening in the room when they're making these recommendations, because that came from the Democratic side. Allow magistrates to set involuntary commitments. Well, they can already do that. That's how it happens now. So you're not recommending any changes. They're already doing that. So what I would say is listen to what Leader Reeves said. Have the folks that are doing the job in the room. Talk to the magistrates. Talk to the district court judges. Talk to the Superior Court judges. And guess what they can do? They can inform you what the process looks like. If you're attempting to tell people what to do, a step for communicate with them about how they're actually doing their job. Yeah, a lot of things were missed here. But there are some things that they're doing right. And if you can figure out how you fix those things, that's what can happen. Last thing I'll say is when I was at the magistrate's office, we had a domestic violence fatality review board. And it goes and looks at all of the fatalities that happen from domestic violence charges. That room is excellent for situations like this. Why? Because it looks for the gaps. In that room, no one's pointing the finger. Folks are saying, yo, what did we do wrong? How do we fix this? And how can we move on? This right here is political theatrics, not actually trying to get to a solution.
I think that's what a lot of people would want, just to say, hey, we know that there are gaps. What can we do to fix it? So hopefully the right people can get in the room and make some changes.
I hope that it happens sooner than later.
Yeah. All right, Khalif. Thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.